Good afternoon, everyone. Um, Welcome to today's webinar conducted under the aegis of the NUS EW Barker Center for Law and Business. The topic of this webinar today is how developers can exercise investors' exercise of conversion rights under convertible loan agreements. And we have a very good panel of industry speakers here today. Let me give a roadmap as to what we are going to, how we're going to go today. First, I will ask the speakers to say a few words about themselves beyond what is already in their bios in the flyers that you have before you when you signed up. Then we will go through the scenario, which is summarized in the bio. And then I propose to cover 7 possible defenses. This is part of a draft paper that I'm writing. And my hope is that our industry speakers will provide an industry sound check on the contents of what I'm putting forth. What is interesting if you look at the bios is that all of them have LLMs. Olivier has an LLM in French law from a very reputable French university. Jocott and Mona are fellow alumni of Harvard Law School together with me, and Mona was actually my batchmate. So all of us here have LLMs, but I do not propose to strain our industry speakers by asking them to do the legal soundness check. That is my job, and I'm going to ask them to provide the industry sound check. So what we are going to do is that I'm going to read out parts of my draft paper for each of these defenses, and then I will ask our industry speakers to weigh in. All this while, if anyone has any questions that you'd like to ask, you don't have to wait until the very end. All you have to do is to type your questions into the Q&A box, and then I will watch out for it, and I'll read the questions as we go along. Yes. So first of all, let me just ask our industry speakers to start introducing themselves. We'll start with the beautiful lady. Mona, would you like to say a few words about yourself?
Yes, thank you, Arvin. So my name is Mona Katigbak. I'm the Global General Counsel of GE Hydro Solutions and GE Hybrid Solutions. These are 2 renewable energy businesses that are part of GE Vernova, which is GE's portfolio of energy businesses. So I sit in Singapore, and it's been my privilege to have actually worked with each of my other co-panelists. Arvin was, as he mentioned, my classmate during my LLM program at Harvard, and also has been my lawyer when with a few disputes that GE Hydropower has had. Olivier, GE has sold equipment to Olivier and his business. And Jocott was at one point the CEO of GE in the Philippines. So I'm very happy to be on this distinguished panel, and very happy to be sharing insights with you all.
Right. Thank you, Mona. Olivier, would you like to say something about yourself?
Yeah, thank you very much. Thank you very much, Arvin, for the invitation, and very privileged to be with Mona and Jocott on this panel. I've been working in the renewable energy sector for 23 years now. So starting in France, in Europe, and then in the US, and then now for the last 10 years in Southeast Asia. So we have been active mainly in wind power, but in every country where there is wind and where there is a commercial way to sell electricity out of wind, looking of course at all other renewables. And the Blue Circle is my second company. I've been entrepreneur also, and built an IPP in France in the year 2000. So very glad to be here. And I don't know again how much I can contribute, but I will try to add my little experience to the panel and to the discussion.
It's well, that's very modest of you, Olivier. I'm sure that you'll do more than that. Let me ask Jocott to say a few words about himself.
Okay. My name is Jocot de Dios, and I work for Manila Water Company. So we're a listed public utility water company in the Philippines. I love a good glass of Ribera del Duero. Has to be very good. I like to run. I cook. I'm trying to find best. I'm trying to achieve the best vongole possible. It is simple. It looks simple, but it's very difficult to cook. But other than that, my day job involves servicing about 7 million customers in our concession area. I've been in the job for a year and 2 months. I joined the group, the Razon Group, a year prior to this, running their construction business, construction company. Spent 8 years in General Electric Philippines, where I worked with Mona. Prior to that, I was looking for oil in the Palawan basin based on Perth. For Nido Petroleum, which is an Australian listed company. By way of renewable energy, unfortunately, my focus had been at the start non-renewable energy sources. I sit on the boards of 2 companies, Oriental Petroleum, a listed Philippine company, and Phoenix Petroleum, downstream oil. But the one thing I'm doing as part of Manila Water, I am really looking at an ESG agenda that I'm driving. Try to make sure we have a very strong strategy for carbon reduction. In fact, I'm pushing for, as we speak, solar installations inside the fence in our facilities. So that's my contribution to the environment. Thank you.
Thank you, Joko. I do have a few apologetic about having acted for conventional non-renewable sources of energy, because that is half of my practice as well. So I do a mix of renewable energy disputes and oil and gas disputes. Recently acted for a Pertamina subsidiary in a $24 million dispute against sorry, Olivier, a major French bank, which we won. And I'm in Seoul right now. I was hoping that we could do it in person today, but unfortunately that is not to be. I think that a practicing lawyer has got to have 2 things. Firstly, he's got to be doctrinally sound, which is why when NUS offered me this adjunct senior research fellow role, I jumped at it, and so I'm conducting this webinar in this capacity today. At the same time, a practicing lawyer has got to be able to help his clients make good commercial decisions. And helping clients make good decisions is largely, I'd say that is 70 to 80% of the practicing lawyer's job. And so that is a mix of common sense, or that is a mix of street smarts. And the thing is, being a lawyer, because you are dealing with a lawyer, dealing with something very intellectual. Still a big part of it is just to be intellectually sound. So I'm very happy to bring all of these together in the form of this webinar today. And we're going to go right into the topic. So the observation is this: it's not an uncommon provision in renewable energy project financing, whereby the investor has the right to accelerate repayment of monies committed and disbursed to the developer. And if unpaid, could allow the investor to convert the debt into equity, and that can be a controlling stake in the developer, either at project level or at holding company level. The commercial rationale behind investors trying to convert is this: convertibles offer flexibility. Upon a conversion, the investor is looking to step in as a shareholder, and depending on its stake upon conversion, look to manage the company so as to protect its integrity and value. Conversely, an acceleration of the debt component offers the option to impose debt due and payable as an alternative route. But for a project which is long dated, and in this case, the value is tied up in long-term development, operations, and revenue generation thereafter, acceleration may not be the strategic interest of the investor, right? But the investor sometimes nonetheless goes ahead and does it. well, that gives rise to this intuition that there might be bad faith involved, which is one of the defenses which we are going to cover. Now, from the perspective of the developer is the most vulnerable at pre-revenue stage, when it has neither the actual funds nor interest from white knights to repay the accelerated demand. But the developer is not entirely without recourse, and there are certain defenses that can be raised to defeat a call on acceleration and then subsequently conversion. And we propose to cover 7 defenses today. First, by operation of shareholding law. Now, in Singapore, in the UK, in Malaysia, and various common law jurisdictions, the Companies Act prescribes that directors require shareholder approval to be obtained for the issuance of new shares for the loan conversion. So in Singapore, that is section 161, subsection 1 of the Companies Act. So just by virtue of this provision alone, if not all shareholders have agreed to the convertible loan, the investor could face an impediment to converting. And in the drafting of the investment agreement and the ancillary agreements, that's something that sometimes is often overlooked. That's a due diligence that has not been done. And that is one avenue that the developer could look to exploit to defeat a call to acceleration and an attempt to convert. So, for example, if there's any pre-existing shareholders agreements between the current incumbent shareholders of the developer company, or the constitutional documents of the developer company contains preemptive rights requiring new issuances of shares to be issued to the current shareholders first, and these have not been waived by the relevant shareholders for purposes of the convertible loan, then the investor could well face a real hurdle. And on this note, I'd like to ask a question to our industry speakers. Actually, there's more than one question. In your experience, and either one of you can go first, in your experience, how often do you see preemptive shareholding clauses posing obstacles to conversions? Now, your experience may be different, your experience may be the same. What I'm going to do is, whatever you say, I'm going to take it into account when I refine my paper. So if you tell me that this is not something that's common, then I'm going to have a rethink about, where I'm going. So I'll ask, is there anyone who'd like to go first? Yes, Mona. I see that you switch your mic off.
I'll go first. Go first, but I think that I just have to caveat this with what my experience has been. So as I said, I'm with GE Renewable Energy. We are not in the business of owning and operating projects. That's not our core business. We are in the core business of selling equipment and operating that equipment once the project has actually been constructed. So whereas GE does have an energy financial services arm, and hang on, I'm also going to caveat this by saying this is my personal opinion, and it is in no way to be construed as indicative of any of any GE positions in any way. Okay, so in my mind, anytime we will lend to a project developer, it is actually in service of GE's core business, which is selling equipment. So I'm saying that functionally to say that I don't want to step into and operate a project. I don't want to own a project. That's not what I do. I sell equipment. I construct projects. I don't operate projects for you. The headaches of selling energy from a project to an off-taker, those headaches, fixing revenue stream, et cetera, those are not headaches that I want. Okay. So to go back to your initial question, Arvin, how often do I see me as a potential investor in a project attempting to exercise shareholder conversion rights? The answer is never. The answer is never. And I actually looked at the last 3 or 4 shareholder agreements that we've negotiated, and I'm not even seeing any shareholder conversion rights. And instead, what I'm actually seeing is, in the event of a default by the the developers, GE has a put option.
Mm.
So what I'm going to do is I'm going to exit. Okay, I'm going to exit. Okay,
Right.
that's instead how I will protect my interests, plus whatever other package of securities that I've got. Okay, so that's my limited perspective, and I'll flick the mic over to Olivier or Jokot if they have any other any other opinions here.
Yeah, no.
Yes. Yes, feel free, Olivia. I think that Jokot has switched on his mic. Okay.
Who, me? Is it me?
Yes. Yeah.
I guess the question is if I've seen any of such preemptive rights and I guess we're limiting it to convertible loans, no?
Yes.
You know, because we play around with prefs, also convertible prefs. So we just stick to the loans. I've not seen it. So this concept is, I guess, probably more a common law than it is for our jurisdiction here. Be that as it may, I would be loath to actually agree to that from the perspective, because obviously we're a listed company, okay, and we're a listed company, but I think about 15 BUs or subsidiaries, well, a few, maybe 10 subsidiaries, different BUs. There's a little bit more, should I say, let's say flexibility, but the ability to try to be a little more probing in terms of how we structure, financing arrangements. At the public listed company level, I had to pay attention to the shareholders. So this is obviously no shareholder would want to be diluted, right? So as well, I don't want to have the headache of having to deal with that. And a lot of the mechanisms that come into play, for example, there's a conversion and there's a potential preemptive. We're just talking about the preemptive right. So I would not even entertain it. There are different ways to actually skin this cat. That said, different lenders have different profiles. It depends. If you're a development of a multilateral, right, your agenda is different from a commercial bank, from a general fund, from a special purpose or a special opportunity fund. So it behooves us, my management team, my CFO, to make sure that we have the right sort of debtor profile, creditor profile to actually provide us that. And obviously, sometimes there are provisions there that because we need to finance heavy capex projects with huge capex requirements, right? We're building a lot of water facilities. We may need to have to bite those, but to the extent that we can push back, certainly the preemptive right is something I would push back on. Thank you.
Thank you. Yes, Olivia.
Yeah, you're touching upon a very sensitive subject, of course. Especially for the developer, owners and entrepreneurs, who are owning the business, and we're seeing, of course, this kind of potential predatory, position taken by mainly the private equity investors. My small experience in this is yes, and you see, of course, mainly again these kind of clauses being pushed by private equity investors, because now with the experience, with my again small 20 plus years of experience with private equity investors, I know now, and even if they swear that is not the case, that they have something in mind. That they have something in mind, of course. And basically, if you're an entrepreneur, I would be very, very blunt. Their target here is to screw you, simply. So, and that's my experience, that these guys are here just to make money, quick buck, and to screw you. So, this kind of clauses, of course, are to be looked at very, very, very carefully, and from my perspective, just put in place and accepted as the last resort. You cannot do anything else. Okay, yeah, let's give them this right, but otherwise, let's try to avoid it as much as you can. And here is just just a general industry perspective. Again, I've been working with both big corporates, big family-owned corporates, old family-owned corporates on one side, and I would say the worst of the private equity funds on the other side. And frankly, the contrast could be cannot be much wider. Even if in the case of corporates, that we can talk about this kind of clauses, and that we can eventually accept it. We will never get to this. We will never get to this point.
Yeah.
We'll always try to avoid, again, of course, confrontation and enforced transfer of ownership of project or companies. Is never good for anyone, and again, also if I just mentioned my experience in Vietnam, which again is nothing to do with what we're talking about here today, but it's it has been also eye-opener for me. In Vietnam, you can sign whatever you want or whatever they want, but if at one stage of the history of the deal, the other party feels that it's not fair anymore, the provisions that you have put in the contract are not fair anymore, and they will just simply tell you, guys, I cannot continue. That's it. We signed something, yes, maybe, but now it's not fair for me, so I will stop doing it. So of course, again, what we're talking about here is not potentially position you can take, but it exists, and again, and it's opening minds where, in fact, yes, the contract is the law of the parties until it's not.
Yeah. So yes, I think Olivier just said about the Vietnam parties feeling themselves bound until they don't feel themselves to be bound. Actually, but it's just a side observation. I wonder whether it's more common in the civil law world. I know you come from France, which is also a civil law country, but my experience, especially with acting for in trading disputes for the seller or the buyer of oil and gas and other commodities, is that sometimes the parties from a civil law countries, right? Let's say they have two contracts. They get back goods. They get the goods that they don't like. Under the first one, they feel that they are totally at liberty to unilaterally cancel the second contract. And so I had a Taiwanese client that did that on one of the disputes. And then my advice was, then you run the risk of being in repudiatory breach of the second contract, which the tribunal found to be the case. And to this day, the Taiwanese company, the CEO of the Taiwanese company, still cannot get his head around why does Singapore law allow for that. So yes, I think that something about this, about this feeling themselves to be bound until they are not bound. Yes. So I'll move on to my second question on this defense, second and last question. Now, if you were coming up with the shareholders' agreement, would you specifically consider putting in such preemptive clauses? So just add a context. So as I mentioned earlier, preemptive clauses requiring new issuances of shares to be issued to the current shareholders first may well be set up an impediment to conversion. So if there's such a simple mechanism available, would you avail yourself of it, or are there any other second-order effects of availing yourself of it, putting in these preemptive clauses that would cause you to consider twice? Maybe again, I'll ask Mona to go first.
Gosh, so again, yeah, I kind of looked over. I did my homework to prepare for this, and what I did was, as I said, I looked over the last few shareholders agreements that at least my business, GE Hydro, had entered into. Okay, so Olivier, not wind. So that might be a different experience. Okay. So again, just going back to Jokot's point earlier about the diligence that an investor does before it actually gets into bed with a company, right? That's the first and biggest hurdle that at least my business needs to overcome before we even consider, jointly developing a project, okay, with a developer like Blue Circle. Okay, so that's the first and biggest hurdle. And the levels of diligence and scrutiny, both technical, financial, personal, etc., that must be overcome are quite substantial. Okay, which is my way of saying that's our protection. Okay, that's our protection, because ultimately we don't get into bed with someone unless we want to be married to that person.
Yes.
Okay, that's basically the perspective that we're coming from. Okay, so in other words, which is why I guess when we're talking about protections, these protections that you're mentioning, Arvin, as I said, they're not in the shareholders agreements that at least I took a look at. Okay, they're not there. For some of the other businesses, for some of the other GE businesses, they might be there, but for my business at least, they're not there.
Yes.
Okay.
Yeah, got that. Olivia, anything to add to that?
Yes. Yeah, a few things. First of all, to put such a clause, it means that you could be as the other party in a position to get the money to in fact protect your rights somewhere. And as you know, developers, we have no money. We never have money. We are always running out of money, and if we were to have money, the money is already invested somewhere. And we have 100 millions of ideas to invest it. So that's the business of a developer, right? So of course we don't have any money. So this kind of right, for me is useless, unless I could in that case, or it would open the door for me to look for someone else.
Right.
Again, okay. But what I have seen, and Arvin, you remember also a situation where we have been, and thank you for advising us in that regard. And there could be a huge conflict of interest, potential conflict of interest, if, again, of course, the debt provider, the financing provider, is also at the mother company level, and in that case, have rights against you, looking at exercising these rights and looking to issue shares to someone else than them. In that case, and that was to my biggest surprise, in the common law environment that we are in here, no problem. The law is, again, the contract is the law of the parties, so no problem. It was in, so they can block you, in fact, and then force you to give away or transfer part of the ownership of the assets of the company, because you cannot, given their rights at the mother company level, they will block you to go and find someone else to replace them. Which in fact, for me, coming from, again, a civil law perspective and training, is shocking. It's really shocking. In the civil law environment, as far as I understand and see, the interest of the company is first. Interest of the company will always be first. That's what we call, the affectio societatis. The affectio societatis, will be this is the main goal of, normally, as Mona said, being in bed with your partners and with your shareholders, and being married and as a common shareholders of a company. So if one of these shareholders is trying to get away with the assets, I would say, take advantage of the situation for his own advantage,
Mm.
in the civil law environment, this is not happening. This is not possible. You go to court, you win for sure, because this is not, you have the proof that is not, they're not acting in not in good faith or in bad faith, I don't care, but in the interest of the company.
Yes.
And that's the interest of the company first, always, which is here again not the case. So we learn every day, which again in the common law environment is different. So to answer your question, I would avoid.
Yes.
Of
Understand. I think yes, whether or not shareholders have a duty to act in the best interest of the company is always murkier. It's clear that directors have a duty to act in the best interest of the company, right? Until and unless you get to an insolvency situation, then the duties may start shifting to the creditors. But shareholders, the situation is a bit murkier. Yes, I agree with you. So sorry, did you say, Olivier, that under French law, shareholders also have a duty to act in the best interest of the company?
Yes, affectio societatis, the affectio societatis must be the rule of the shareholders. Yes, their own interest is going second. Yeah.
Thank you. Yes. Later, I'm going to ask you to WhatsApp me the French term to yes, because I'm writing up the notes. So later on, I'm going to ask you to WhatsApp me the French term. Yes. Jocott, anything?
I try to approach this from a different tack, right?
Right.
And I'm drawing from my current experiences running Manila Water and the subsidiaries. Conversion, again, it goes to the first statement. Your lender, it'll depend on the lender, depend on their motives and their policies.
Yes.
Lenders typically really just want to get their money back. They want to get repaid with their coupon and their interest, right?
Yes.
You think to Mona's point, lenders will not lend money to get an in into a project. Generally, there are lenders that are looking at it as a special opportunity to get into that business, and that's fine. Maybe as a default, there are commercial banks here that do that. So that said, it's uncanny or intuitive for lenders to just do that. So being the case, at least from our perspective, at least on the Manila Water parent, number one, there are no shareholders agreements, no. So there's really nothing to give rise to what you had alluded to with respect to these preemptive rights. The second aspect is the one thing shareholders want to avoid is dilution.
Yeah.
So that's the second concept.
Yes.
Lenders want to get paid their money with interest. Shareholders don't want to get diluted.
Right.
So between those two interests,
yes,
a conversion with preemptive rights may not work for those reasons. I can just imagine how difficult it is to actually get into that sort of an arrangement.
Yes.
With the land, unless you really are, you have to go to a pirate fund or a special opportunity fund, and you have no choice. And then maybe that too, but there's liquidity in the market. Now, from our subsidiaries that are doing deals, we're doing one now in Southeast Asia, right, for a project, and our potential acquisitions we're looking at. I'd like to avoid that as a shareholder. I don't want to have the project company borrow money and then potentially have the lender dilute me. I want to choose the lenders.
Yeah.
Right. That's the defense. To me, that is more the defense. Otherwise, we get bogged down in 12 months of negotiating the mechanism, etc., etc. This particular deal, it's not even on this matter, but free carry. Oh, that's back and forth. So I'm sure there are other ways to try to figure out a way forward. But those are my thoughts.
Yeah.
Got it. Yes.
Totally agree. Yeah.
Yes, I see there's a general consensus here. So that's very interesting. I'm going to consider it very carefully when further writing up this paper. Well, just side note, everyone seems to agree that no shareholder wants to get diluted, and generally yes, but the nature of my practice is I always seem to be doing all the outlying cases at the margins. There was one case that was asked to, and this was a One Belt One Road project. So my client was a Chinese company called Shanghai Decent, and they had a big stake in this, not a majority, not even controlling, but big enough stake in this Indonesian company that owned Indonesia's largest iron nickel project called PT Sulawesi Mining in West Tama. And the China ASEAN Fund, which is the One Belt One Road vehicle for China, was going to invest $50 million to buy over a stake in PT Sulawesi Mining Investama, which would dilute my client Shanghai Decent. But my clients merrily gave me the instructions to go ahead, and they were determined to have that happen. I think they saw it as a matter of national pride. That's the China ASEAN Fund, the One Belt One Road project was getting such a strong foothold in Indonesia. Anyway, that was an outlying deal. Now, moving on to the next defense, we were talking about good faith, and Olivia started off the idea, the idea that it's bad faith and good faith and common law and civil law, and this is where the themes intersect. Generally, as a matter of common law, contract law, English, Singapore contract law, there is very little duties of good faith. It is all caveat emptor, caveat venditor, right? And you come in with a wise-eyed open. There are maxims such as chancery man's no man's bargain. You take on a stupid deal. Well, you play stupid games. You deserve to win stupid prizes. Suck it up and go ahead with it. Interestingly, there is a movement in both English and Singapore jurisprudence towards an emerging duty of good faith in the performance of contracts. So there was this English High Court case in 2013 called the Yam Sing Private Limited and International Trade Corporation Limited. Well, Yam Sing, and I think that is literally, well, that's the word for, that's a Cantonese word for, well, santé in France. And yeah, so anyway, so the court in that case said that the test of good faith is an objective one in the sense that it depends not on either party's perceptions of whether a particular conduct is improper, but whether in the particular context, the conduct will be regarded as commercially unacceptable by reasonable and honest people. So it's quite interesting that we have a very simple formulation. Is it commercially unacceptable by reasonable and honest people? If it's commercially unacceptable, then yes, prima facie bad faith. But if not, then well, that's a different story. So the Singapore Court of Appeal, not subsequently, around the same time in 2009, considered this issue in this case called Ng Yap Horn and Westcomb Securities Private Limited. So Justice Andrew Pang described the doctrine as a fledgling doctrine in English and Singapore contract law, and declined to accept that a term could be implied in law, obliging parties to perform their contracts in good faith. However, he did indicate that he was prepared to accept that based on the particular factual matrix before the court, a term of good faith, in fact, could be implied. So it's not going to be, it's not a question of law. It always turns on the facts. So this doctrine is slowly being adopted in Singapore. And in 2015, there was a Court of Appeal case, the One Suites Private Limited and Pacific Motor Credit Private Limited, which considered the decision of the English High Court in Yam Sing and determined that the court would make pronouncements at an appropriate case and stated that the law in this particular sphere continues to be in a state of flux. That means we're not close to this idea. Then comes this year, 2022, and there is a case that was heard by the Appellate Division of the Singapore High Court, Ng Kun Yi Miki and Ma Sao Cheong, which says, although the precise scope of the implied duty is to be determined on the facts of each case, it can be observed from the cases that the scope of each duty will be limited by the express terms of the contract, as well as what is necessary to give the contract efficacy, and is not meant to impose an onerous obligation on the parties to the agreement. This conclusion accords with the Court of Appeal's holding in the One Suites that where there is an implied term to use reasonable endeavors, the steps that must be taken to satisfy the obligation will depend on all the facts and circumstances of the case itself. The Court of Appeal also reiterated that where relevant, the court is to have regard to the express terms of contract itself to determine the scope of such an obligation. So it looks like it's quite promising. Singapore law is quite promising. There seems to be an emerging duty of good faith, right? And so the investor therefore may consider a strategy of seeking a declaration of bad faith in accelerating, of bad faith in the the developer, rather investor, the developer may consider a strategy of seeking a declaration that the investor was acting in bad faith in accelerating and or exercising conversion rights. Now, even while the case law is only gradually emerging, this, well, seems to be the general direction that Singapore law is going in. So now, industry sound check time. On the face of it, an investor accelerating repayment when it has contractually provided for a specific period for repayment, right? So if, let's say, something is to be disbursed in 2 tranches, 25 million each time, and the first tranche is to be due in, say, 2 years' time to allow the developer to be able to use those funds to develop the project, right? On the other hand, there is a clause saying that notwithstanding that the period, the tenure is 2 years, we can at any time accelerate repayment. So if there is a specific period, in this case 2 years, that's provided for, it appears to be acting then in bad faith. Yeah. So yes.
Sorry, Arvin, just as a question, are you seeing that in your practice, that that there are clauses that are permitting, acceleration for no reason, like at will, essentially, like at will?
Yes.
Yes. Interesting. Interesting.
Yes.
So because I just from again industry sense check perspective, right?
Yes.
I'm imagining, again, I would be negotiating this against Olivier as an example, but that's not anything that I would have requested. I would only ever request an acceleration for certain specified events of default, as an example. Okay, so that's a badly negotiated document, I want to say. Right?
I mean, it is more the case that is, the case that will not be the case if the developer has got leverage against the investor. But I've seen that before, where the investor had a lot more leverage against the developer. So you have raised a very interesting point, because as a matter of common law, when is a debt repayable, right? And the standard answer that usually shocks people is that it's repayable almost immediately, unless there is a specified tenure. If there is a specified tenure, then it cannot be repayable immediately. You have to follow the tenure. But the accelerated repayment clause gives a tenure, then takes it back again to the old stage by saying, notwithstanding that there's this tenure, I can ask for it at any time. And because it is agreed on, I mean, parties are free to agree on anything, and because that is the default position at common law, so there's nothing wrong with that.
How interesting.
So that's the way to conceptualize it, yes. So, so maybe my question to you is, can you think of any instances when accelerated repayments may be justified, notwithstanding that there is a fixed specified tenure? If you can think of no situations, then I think that my bad faith argument will be even more normatively stronger. But if you can think of some, then
not justified at all. I wouldn't enter into that agreement if there was that provision.
Right. Just from a sense check, doesn't smell right kind of provision, right?
Yes, that's right. Olivier, any thoughts?
For me, financially, again, no, because most of the time, not 100% of the time, but most of the time, I would say, in case of default on a debt, the main and 99% of the case solution, best solution is just to reschedule the debt.
Right.
As easy as it is, there's nothing which could preclude the parties to just reschedule the debt. So no. I agree with Jokot also. I will not enter into such an agreement, and I don't think I have seen ever such an agreement where the lender or investor could accelerate the repayment that is on hand on choice. Never seen that.
Great. Okay. So it looks like this defense is particularly powerful. Fantastic. Okay. Now we move on to the third defense, which is, it's the uncertainty. You will then go and look at the conversion mechanism to see whether it has any uncertainty, whether it is commercially workable. Intuition for this came about because Many years ago, around 10 years ago, I was working in the DIFC courts in Dubai, and Lord Justice Chadwick was a retired Court of Appeals justice in England. Was working there, worked quite closely with him. A few years later, I was lead counsel on a case when there was a clawback clause in a insurance employment contract, and I was thinking of all kinds of ways of how to defeat that clawback. And I was finding it hard going. And I met him for lunch in London. I met Lord Justice Chadwick for lunch in London, for dinner in London, actually. And I told him that I was in this quandary. What do you suggest? And he said, why don't you look at my recent decision in this Cayman Island case called Enris and Fennismore. So Lord Justice Chadwick was also president of the Cayman Islands Court of Appeals. And he held that a clawback clause was unenforceable, not to be given effect, because if you take its parts, if you consider all its parts and you run it through various scenarios, you run it through various counterfactuals, it does not work. It leads to absurdities. So on that basis, you can then ask the court to issue a declaration that that clawback clause is unworkable. So based on that intuition, I think that it is fair game to then say that let's look at a conversion mechanism and see whether we can come up with a case that trying to run it through to its logical conclusion would lead to absurdities. So for example, if key features of conversion, such as the rate of conversion from loan to shares, the window to exercise the option to convert, etc., are not clearly specified, the investor may find it worthwhile seeking to resist the conversion on the basis that the conversion mechanism is void for uncertainty, or that the exercise of conversion requires a subsequent agreement to agree. And this agreement to agree is particularly interesting. Until recently, the Singapore courts had consistently taken a position that all agreements to agree are unenforceable. So if you leave out key provisions as to conversion and say we leave it to a subsequent agreement, then immediately that is unenforceable. And there was a case in 2010 called Sundar Ken Limited and Salzman Anthony David that said so. So in that case, the Singapore High Court applied the classical English case, which is Walford and Miles, and explained that the reason why an agreement to agree is unenforceable is simply because it lacks the necessary certainty. But Singapore law has started changing its mind on this. And there's a recent case in the International Research Corporation PLC and Lufthansa Systems Asia. So the court in that case held that in light of its held that a reconsideration of this classic position was appropriate. So in a slightly earlier case in 2012 in Singapore, the Court of Appeal held that an express agreement to negotiate in good faith, which forms part of a broader contractual framework, and in that case, which was a rent review mechanism under a lease agreement, could be enforceable. So the guidance that the courts provide as to when an agreement to agree can be enforceable includes whether it is clear when the duty to negotiate arises and whether the provision contains sufficient objective criteria to determine what the result of the renegotiation ought to be. So everything is up in the air, and I think that in order for me to make sense of it, I'm going to see whether I could get any industry perspectives on just two issues. How often do you instruct? How often would you instruct your lawyers to be specific if you are going to come up with a convertible loan agreement, right? How often would you instruct your counsel? In your case, Mona, how often would you be instructed to be specific about the conversion mechanism, such as the rate of conversion from loan to shares, to exercise the option to convert, or other factors? Is that something that you would immediately think of right at the start, or is that something that in your experience most people leave through until the end? Mona, would you like to go first?
Hi, yeah. So I guess we as a transactions lawyer, we're in the business of specificity, right? I don't like leaving things to chance. I don't like ambiguity. I don't like vagueness. So if we were to include a mechanism like that, we would absolutely attempt as far as is possible to spell out with specificity, okay, circumstances for conversion, specific mechanism, et cetera, et cetera, et cetera. So yeah. So that's what we would do. But I'm just mindful of a comment that Jokot made earlier on our prep call, which is, the difference between a deal lawyer and a desk lawyer. And I do very much consider myself to be a deal lawyer.
Right.
Okay. So then you would go to the practicality of when you're drafting a contract, you're not bogged down in unnecessary things, but you're looking at how will this actually work and how will this actually play out in real life. Okay,
right.
So that's what would drive how you would negotiate and draft that contract. Okay, so that's me. And I will bow to the people who actually do instruct their lawyers.
Okay.
Let me, as well. Of course, I would have to. I don't want ambiguity.
Yeah.
Right.
You rush a deal for the sake of closing it. And I get reminded because I have a tendency to push. Commercial and the com-ops teams, the commercial folks try and close this deal.
Yes.
Then the lawyers will say, wait a minute, I have this and that and the other. I said, no, push.
Yes.
But you have to appreciate that, in 3-5 years, carelessness to get this deal done might bite you in the end. So that's the default. That said, that's the tricky part, because there lies the balance on what level of detail is sufficient for you. And we're talking only in the context, that's in general, but conversion rights mechanism, my God, I can imagine a lot of protracted discussion on formula, parameter, blah, blah, blah. I'd rather not have it. To be honest. Obviously, if I'm the lender, I'd like to.
Yes.
If I was being asked by let's say a local water entity in the Philippines to provide some debt, financing, or whatever, that's the first thing I'd want. Right? It depends on your perspective. I'd like a convertibility feature, especially if they're a little shaky in terms of we have a lot of water districts and water companies. I'd like that. But if I shoes on the other foot, I'd resist. But in any event, it has to be clear, crystal clear.
Yes.
Yes.
Yes. Is that your sentiment as well, Olivier?
Just one point. From my experience, convertible loans or loans with a way to have access to the assets. There are two ways. There are the convertibility or the access to the assets could be a major point or just a feature of the deal.
Right.
And sometimes the provider of the financing are here to provide financing. That's it. No access to the asset, no convertibility. It is in the name, or it is in the drafting, just security, but a security not to be called.
Right.
So in that case, of course, everyone is more relaxed, as Jokot mentioned also, and in that case, everybody could be more relaxed. Okay, you're here to lend money, not to screw me, not to take over my assets. So there's no, in that case, to answer your question also, Alvin, I will not, particularly instruct my lawyers to be, to push and to fight on this one, because it's agreed that it's just a feature of the deal.
Yeah.
Yes.
But we will not, the conversion mechanism will not be, or will be at the level that is not really enforceable, or it will not work to be enforceable. So that's one thing. On the other hand, if, and I was referring previously to the private equity investors, if in fact the actual target or main target would be, oh well, I give you money, but careful, the first minute you don't repay me, well, your assets are going to my side. So in that case, of course, it means a lot of negotiations, a lot of hours, and of course, a very, very, very high attention from the asset owners, potential asset owners, and the instructions to his lawyers to work, very specifically on this, and of course to push the conditions, towards the developer, of course.
Got that? Yes. Thank you. We're in this situation of a bit of a conundrum. We have gone through 3 defenses and we had some very robust and great views. I want to carry on with the other 4, but I realize that there's 5 minutes left. Fortunately, the other 4 are minor compared to these, although there's one on liquidated, whether it's a penalty clause, right? Which may be worth fleshing out. I now have a choice between powering through and dealing with that in the last 5 minutes, or to take a question from the audience. And I think I should reward the audience for staying through all the way. So I think I'm not going to power through with that. And I'll ask that question from the audience. And it seems to be for Joe Court, but of course, Mona and Olivier can feel free to chime in as well. It says this: good afternoon, Mr. Didios. May I clarify why preemption clauses would go against shareholders' interests? Open bracket, if I'm understanding you correctly, close bracket. If shareholders' interest is not to be diluted, wouldn't ensuring that new shares are issued to current shareholders first prevent shareholders' shareholding from being diluted?
No, that's correct. It's in fact, having preemptive rights will not is actually a mechanism to protect the existing shareholder. What I mean to say is that that's correct. That shareholder does not want to be diluted. But on the other hand, you have the lender. To him, he will value. Again, I'm coming from the perspective that I'm depending on it. I'm a lender. I want to get my money back.
Yes.
If you add a feature of conversion and there's a preemptive right, then you get into this dogfight about, all right, the premise of issuing the of having that conversion right is for me, if I'm just a pure lender, to be kept whole on the money that I sent. I've
Yes.
given. If at the end of the day, we're the same, you keep me to a certain percentage and that affects or impairs my ability to be kept whole economically, then I'll have a problem with that. So it'll be a dogfight to try to protect, for him to ensure his economic interests are protected. But then again, conversion rights are typically, are typically triggered by default of the developer, no?
Yes.
So it's already pretty much a distress situation. So you add, in fact, the fact that he'll still be diluted on a distressed company might limit very much your universe of lenders who would agree to it. I'm saying, go ahead. If I were faced with that situation, I'd say, if I was a shareholder, I'd do the same thing. I'd say, let's have preemptive rights so that I'm not diluted. I'd even insist more, because if it's a conversion, it presupposes a breach. We're not able to comply with our obligations, hence the enterprise is a little bit in trouble. I would be hard put to find a lender who will agree to that, is all I'm saying.
Right. Okay.
Yeah, exactly. Yeah. No, exactly. I think we're not talking about the same thing, and definitely, yeah, the lender will not agree. I think that will not agree with preemptive rights toward, to protect the owner. Where you're totally right. They are supposed to be there to protect their interest as a lender. So it doesn't work out.
Okay. Yes. So I think that well, I don't know whether my industry speakers are now relieved that their job is over. I actually wish it would, you'll go on some more. And I have to say that, given the quality of the discussion today, I would very much love to invite you all back for, now I know how articulate and how good you are in expressing your views and to, and to connect with the questions. I am very tempted to invite you again. I mean, at the same time, I think to the audience, you may want to know that all 3 speakers are my clients. And one of the things I always go on, as a lawyer, is you always try to safeguard executive time jealously, so that so I think I'd better not impose on my clients too much, but I will ask them privately whether we could have another session, because I think that it's going really well. It's one of the better sessions that I've conducted seriously. So I would thank, I think it just leaves me to thank Mona, to thank Olivier, and to thank Joe Court for their time. And if there are any follow-up questions, feel free to get my email address from the administrators, and I'll see whether I can answer them. Olivier, Mona, Joe Court, any last words for our audience? Okay, great. So thank you.
Manila Water shares is my last word.
Great. Okay. Thank you very much, everyone. Yes.